So earlier I mentioned that Section 515 of the Criminal Code sets out three principles that a judge is supposed to look at in order to decide whether or not to let you go. So those three principles are, first, making sure that you'll show up in court. Second, making sure that the public is protected if you're going to be released, and also making sure that whatever decision the judge makes will ensure that the public maintains confidence in the administration of justice. So let's look at each of these in a little more detail. The first one there is making sure that you show up in court. What kind of evidence is going to be relevant at a bail hearing for a judge to decide whether or not this is a concern? Well, the prosecutor is going to be sure to point out any previous failures to appear that show up in your criminal record, right? Because those are convictions that show up in your record if you don't show up to court. Often the sentences for these can be relatively small, but when they pop up a lot in your criminal record, even if you don't end up being sentenced to a whole lot of time for them, they usually mean that later on down the line when you ask to be released on bail, a judge is going to be very skeptical and is going to point out to the fact that, look, the other times we needed you to be in court, either just for a court date or for your trial, you didn't show, and that's a big problem. There's also going to be a question of whether or not you have ties to the community. This pops up a lot when you have somebody who's from another jurisdiction. Let's say I'm a person from Ontario and I'm arrested in Alberta, and then I go in front of a judge, and the judge says, well, who's to say that if we release you on bail, you aren't just going to head off back to Ontario? They might be very concerned that you don't have enough reasons to stick around and come back to court, even if you don't have previous failures to appear. So sometimes you will need to do something to convince the judge that, yeah, even though I don't have ties to the community here, I am going to be here for court. Also, on a similar vein, if you've got residences, especially in another country, another continent, if you've got a life elsewhere, if you're somebody from Ireland and you're arrested in Alberta, then they might be very concerned that they can't trust you to come back for your court date. Any other reasons you might flee the jurisdiction aside from your failures to appear? Like, let's say you maintain that, actually the mob in Alberta, the Alberta mob is after me. Then the judge might say, well, based on that, we think you're probably going to run away as well. The evidence is going to be relevant for the second section, the protection of the public, likelihood to reoffend. We already saw that your criminal record is significant if there's previous failures to appear on there. But for the second principle in Section 15, this idea that we need to protect the public, the judge is going to look at your record, and if the judge decides, well, this guy has a lot of convictions on here, the judge might say, well, in order to protect the public, I'm going to have to keep you in jail until your trial. This is kind of weird in a lot of ways because you've already been sentenced for those crimes, right? You've paid your debt to society for anything that appears on your criminal record. And here you are kind of being punished again on the basis that you're the kind of person who might do this again. But that's essentially what the criminal law allows for. They'll especially look and see if you've got a lot of convictions for breach of probation or for breaking the conditions of your bail in the past. Because they're really sort of looking to see, is this the sort of person who has trouble following rules that a court has set out for him? And if you do have a lot of breaches of probation, a lot of breaches of conditions, that's going to be a problem if they show up in your criminal record. Another big issue under the second ground is when they talk about protection of the public. Specifically, they're talking about protection of people who might be involved in your trial, right? If they think you could be a danger to witnesses in the trial or to the principal victim or victims, then they'd say, well, to ensure that the trial is going to go off without a hitch and that we're going to have a legitimate verdict, we don't want you out there intimidating witnesses. If they are afraid of that, then they might keep you in, because this can happen, right? Like, it could be that at your bail hearing, they have a phone call from the day that you actually made from prison to one of the witnesses trying to discourage a witness from testifying. If they have a recording like that, that certainly doesn't look good at your bail hearing. They also, and again, this is where it's strange that they are essentially punishing you for not for crimes that you've done, but for crimes that you might do. They look at your previous crimes and say, well, based on this guy's probably going to commit another crime if we let him out. It's like, well, actually, shouldn't I be allowed? Like, isn't that the whole idea of the criminal law, that it only punishes you for crimes that you've done, not for crimes that you would do in the future? Like this image here, you might recognize this if you know the movie Minority Report, based on a science fiction work where they have these precognitive people who essentially predict the crimes that you're going to do, and they arrest you before you do them. Normally, we don't like to do that in modern day. We don't say, well, we know you're going to commit a crime, so we're going to stop you from doing it. But that's kind of what happens in the bail hearing. They say, well, in order to protect the public, we know this guy has a tendency to commit crimes, so let's keep him in until his actual trial. The third principle is the more nebulous one. It's the least frequently cited at bail hearings. Judges will sometimes have to rely on this if it doesn't really fall in one of the other two. It's a very high-profile case where the evidence against you is very, very strong. They might say, well, even if this person doesn't have a history of not showing up to court, the evidence seems pretty strong to show that this person, killed his parents or whatever it is. And the public would get pretty upset that the system is a joke. Really, that's what they're concerned about. They don't want the public to think the system is a joke. So if they figure that releasing a person or holding a person would convince the public that the system is a joke, then they're going to use that in their reasoning. Sometimes this can involve reusing evidence from protection of the public. If the public would look at this and say, I can't believe they let this guy, who clearly we've got videotape recording of him stabbing his parents, and this guy's just walking around waiting for his trial. If a well-informed member of the public would think that this is absurd, the judge is supposed to take that into account on the third ground. Now, the defense, your lawyer, if you're the person who's been arrested, the defense lawyer has a chance to try and convince the court that there are measures that can be put in place to make sure that those three principles aren't in danger, right? The defense can often suggest that there be a cash deposit. That's often when we think of bail, we think of it as money. But it might surprise a lot of you guys to know that in Canada, very often you're allowed to just pledge an amount of money and not deposit it with the court. We have a very different system from the sort of bounty hunter cash bond system in the U.S., where, yes, it can be the case that the court will hear you suggest, well, maybe I could deposit, $1,000, and that'll ensure that I come back for it, and the judge might accept it. But that can also happen without any actual money changing hands. What you'll often see a good defense lawyer propose at a bail hearing is if they know that the person's record doesn't look very good, but they know that this person maybe has a respectable relative who can be brought in as a surety. That's like a kind of like a guard who tells the court, look, I know this guy may have had his problems in the past, but I'll be sure to keep him in line. I'll have him respect whatever curfew the judge imposes while this guy stays at my house. I'll keep a close eye on him, and I'll make sure that he doesn't do anything between now and the trial. Then that can often persuade a judge, okay, well, this might be safe enough to let this person out as long as you've got this person watching over them, guarding them. And you can also have, if you're worried that the person might not show up to court, you can specify that this person twice a week or even every day is going to go to the office, the police station, and sign the register saying, yeah, I'm still here. I haven't run away to Hawaii or whatever it is. And you'll know, like the first day that I don't show up and sign in, you'll know to start looking for me because then maybe I've run off. So these are all measures that your defense lawyer might put forward to try and reassure the judge, yeah, you can let this person out because they will come back and they won't commit any crimes in the meantime.